Before we begin, a quick and important disclaimer. This video is intended strictly for educational and entertainment purposes and does not constitute professional legal, financial, or psychological advice. Divorce laws, mediation practices, and economic conditions vary significantly by jurisdiction and individual circumstance. We are discussing historical trends and retrospective data, which may not reflect current legal standards or individual outcomes. You should always conduct your own due diligence and consult with a licensed attorney or a certified financial planner regarding your specific situation before making any decisions related to matrimonial law or asset division. Imagine a world where the American dream was at its absolute peak. The 1990s and the early 2000s were defined by skyrocketing 401ks, a housing market that seemed to have no ceiling, and an era of unprecedented consumer confidence. But behind the white picket fences of the U.S. economic boom, a quiet revolution was happening in the hallways of the American legal system. While the headlines focused on the Dow Jones hitting record highs, a massive shift was occurring in how families dismantled their lives. In an era of excess, the most expensive thing you could do wasn't buying a private jet. It was getting a traditional litigated divorce. This was the era where divorce mediation moved from a fringe, alternative hippie concept into the mainstream boardrooms of high-net-worth separation. We are going to look at why, during the wealthiest period in American history, the smartest players in the game weren't hiring pitbull litigators to fight in open court. Instead, they were retreating to quiet conference rooms to settle their differences in private. By the end of this deep dive series, you will understand the mechanics of how wealth preservation and mediation collided during the boom, and more importantly, how those historical lessons are the only way to protect your assets in today's much more volatile economy. If you think mediation is just about being nice, you are about to see how it was actually used as a high-level financial strategy to prevent the legal system from liquidating the American middle and upper class. During the economic expansion of the late 20th century, the United States saw a surge in household wealth that was historically unprecedented. However, this wealth created a paradox. As assets grew, think tech stocks, burgeoning real estate equity, and complex retirement accounts, the cost of fighting over those assets in a traditional courtroom grew exponentially. We saw a trend where the winner-takes-all mentality of litigation started to result in everyone loses, due to the sheer volume of legal fees. In a standard litigated case in a major U.S. metro area like New York or Los Angeles, it wasn't uncommon for legal fees to cannibalize 15 to 20% of the total marital estate. Mediation emerged not just as a social preference, but as a fiscal necessity. Let's look at a case study from the mid-1990s. Consider a couple with a combined net worth of $2 million, largely tied up in a primary residence and a burgeoning portfolio of NASDAQ stocks. In a traditional adversarial setting, each party would retain a high-level litigator. These attorneys would then hire forensic accountants, vocational experts, and child custody evaluators. By the time the case reached a trial, often 18 to 24 months later, the legal bills could easily exceed $300,000. In contrast, mediation during this same period offered a potential outcome where the same couple could reach an agreement in 3 to 6 months for a fraction of that cost, often under $20,000. The economic boom created a time-is-money culture. High-earning professionals realized that every hour spent in a deposition was an hour they weren't billing clients or managing their investments. Mediation allowed for a streamlined process that mirrored a business negotiation, rather than a moral crusade. This shifted the focus from, who is at fault, to, how do we divide the pie so both parties can continue to participate in the ongoing economic expansion? The rise of mediation was also fueled by the specific nature of assets during the boom. We weren't just talking about cars and savings accounts anymore. We were talking about unvested stock options, intellectual property, and the valuation of blue sky in family-owned businesses. The public nature of a courtroom meant that these sensitive financial details became a matter of public record. For the rising executive class, privacy was a commodity. Mediation provided a confidential forum where these complex valuations could be discussed without alerting competitors or the public to the inner workings of a private enterprise or a high-level compensation package. Furthermore, the boom era introduced the concept of the no-fault evolution, meeting the equitable distribution revolution. As more states moved toward equitable distribution models, the math became more complex. It wasn't a simple 50-50 split. It was about what was fair based on contributions, future earning capacity, and the duration of the marriage. Mediation became the laboratory where these complex formulas were tested. Mediators, often retired judges or specialized attorneys, acted as neutral evaluators who could help parties understand the historical trends of how a local judge might rule, without actually having to step foot in front of one. Let's talk about the psychological shift that accompanied this economic reality. In a period of growth, people are generally more future-oriented. When your portfolio is up 20% year over year, you are less likely to obsess over a small grievance from 5 years ago, and more likely to focus on how to move forward. This abundance mindset was a secret engine behind the success of mediation in the 90s. It allowed for creative problem-solving that litigation simply didn't support. For instance, instead of forcing the sale of a family home during a peak market, which would trigger massive capital gains taxes, mediators helped couples navigate nesting arrangements or deferred buyouts that kept the asset growing while the family transitioned. The step-by-step reality of a boom-era mediation usually followed a specific trajectory. First, there was the information-gathering phase. Unlike the discovery phase in litigation, which involves aggressive subpoenas and long-winded interrogatories, mediation encouraged a transparent exchange of documents. In an era where digital record-keeping was just beginning to take hold, this was a massive time saver. Second was the definition of issues, where a mediator would strip away the emotional baggage to focus on the 4 pillars: asset division, debt allocation, support obligations, and parenting time. Data from the early 2000s suggests that mediated agreements had a significantly higher rate of voluntary compliance compared to court-ordered mandates. When people feel they have a hand in crafting their own future, they are statistically more likely to stick to the deal. In the context of the U.S. economic boom, this meant fewer return trips to court for enforcement actions, further preserving the wealth that had been built during the marriage. This masterclass is going to dissect these historical trends because we are seeing the echoes of this era today. The strategies used by the elite during the 90s boom to safeguard their fortunes during a divorce are the same strategies that savvy individuals are using now to navigate modern complexities like cryptocurrency, remote work, jurisdictional issues, and the volatility of the current housing market. We are going to look at the specific mediation blueprints that were developed during this golden age of the American economy and show you how they redefined the legal landscape forever. This isn't just a history lesson. It's a deep dive into the evolution of conflict resolution and wealth management. To understand why mediation became the gold standard for the American elite during the economic surge, we have to look at the specific anatomy of the 1990s bull market and how it complicated the traditional legal framework. We are talking about a time when the gross domestic product was growing at an average of nearly 4% annually, and the unemployment rate dipped to its lowest levels in 30 years. This created a generation of what historians now call the accidental millionaires. These were individuals who weren't necessarily born into wealth, but found themselves holding massive paper gains through 401ks and employee stock options. When these marriages began to dissolve, the traditional court system was woefully unprepared for the velocity of this wealth creation. Imagine a scenario in 1998 involving a character we will call David, a mid-level manager at a burgeoning tech firm in Northern California. David and his spouse, Sarah, had been married for 12 years. In 1992, their net worth was negligible. By 1998, David's unvested stock options were valued at $4 million. In a traditional litigation setting, a judge would have to determine the community property interest in those options. But here was the problem. The law was lagging behind the technology. Should the options be valued at the date of separation, the date of the trial, or the date of vesting? If David and Sarah went to court, they would be at the mercy of a judge who might still be learning how a browser works, let alone how to calculate the present value of a derivative security. This is where the tactical advantage of mediation became undeniable. Instead of a gamble in a courtroom, David and Sarah sat down with a mediator who specialized in executive compensation. They didn't just split the shares, they created a structured rollout. They utilized historical trends of the market to build a contingent settlement. If the stock hit a certain strike price, Sarah would receive a specific percentage. If it dipped, the distribution adjusted to protect David's ability to pay future support. This kind of sophisticated, nuanced financial engineering is almost impossible to achieve in a 15-minute hearing in front of a harried family court judge. The economic boom also saw the rise of the two-income professional household. By the year 2000, more women were entering high-level management and legal professions than ever before. This changed the math of alimony, or what we now call spousal maintenance. In the old world of the 1970s and 80s, the calculation was often a simple percentage based on the husband's income. During the boom, mediators had to account for two high-velocity careers. They began using a technique called the vocational evaluation within the mediation process. Consider a case study from 2002. A dual-income couple in Chicago, both earning six figures, decides to part ways. In a litigated battle, they would spend $50,000 each on experts to prove who worked harder or who sacrificed more for the other's career. In mediation, they hired one neutral expert to perform a career trajectory analysis. This expert looked at the potential outcomes of both career paths over the next decade. Based on this data, the mediator helped them craft a rehabilitative support plan that phased out as the lower-earning spouse hit specific career milestones. This saved them not only the cost of the experts but also the permanent resentment that comes from being cross-examined by a spouse's lawyer. We also have to discuss the role of the 1997 Taxpayer Relief Act during this period. This piece of legislation significantly changed the capital gains tax on the sale of a principal residence. For a couple in the midst of a boom-era divorce, this was a massive strategic lever. Before this, many couples felt forced to stay in unhappy marriages simply to avoid a massive tax hit upon the sale of their home. After 1997, a married couple could exclude up to $500,000 in gains. Mediators became the primary educators for the public on how to time a divorce to maximize this tax exclusion. Imagine a couple in 2026 looking back at these records. They would see that the most successful mediations were those that functioned as a tax optimization strategy session. A mediator would walk a couple through a step-by-step analysis of their portfolio. Step 1. Identify the cost basis of every joint asset. Step 2. Project the tax liability of liquidating those assets in a divorce versus holding them as individuals. Step 3. Offset the high tax burden assets with high growth potential assets to create a net neutral trade. This level of granular detail is why mediation moved from being a soft, emotional process to a hard-nosed financial discipline. The sheer volume of paperwork in a boom-era divorce was another catalyst for the shift. As the U.S. economy became more digitized, the amount of financial data exploded. In a traditional lawsuit, the process of discovery, the legal term for exchanging information, became a weapon. Lawyers would bury the opposition in thousands of pages of credit card statements and bank records, charging by the hour to review every line. This was known as a document dump. Mediation neutralized this tactic. In a mediated environment, the parties agreed to a formal, streamlined disclosure process. They often used a joint forensic accountant, which essentially cut the professional fees in half immediately. By 2004, the data started to show a clear trend. Mediated cases were closing 70% faster than litigated ones. In a fast-moving economy, that speed was worth its weight in gold. If you were tied up in court for 3 years, you missed out on 3 years of reinvesting your share of the assets into the market. For a couple with a $5 million estate, a 3-year delay at an 8% annual return meant they were effectively losing over $1 million in potential growth just by waiting for a judge to sign a decree. The smart money realized that paying a mediator $5,000 a day to settle in a week was the best investment they could ever make. But there is a darker side to this retrospective. The ease of mediation during the boom years sometimes masked a growing disparity. Because mediation relies on voluntary disclosure, the party with less financial literacy was often at a disadvantage if the mediator wasn't rigorous. We began to see the rise of the financial neutral, a third-party professional whose only job was to ensure that the data being used in the mediation was accurate. This led to the creation of the Certified Divorce Financial Analyst, or CDFA, a role that became essential as the boom reached its peak. These professionals provided the historical data and future projections that allowed mediation to move beyond simple compromise into the realm of strategic asset management. This brings us to the most controversial aspect of boom-era mediation: the valuation of the future. During the tech bubble, companies with no profit were being valued at billions. When an entrepreneur got divorced in 1999, how do you value a company that might be worth nothing tomorrow but is worth $1 billion on paper today? The mediation rooms of Silicon Valley and Alley were the first places to develop the clawback agreement and the equity split decree. These were complex legal instruments that allowed a spouse to benefit from a future initial public offering or acquisition, even after the divorce was finalized. These structures, born of necessity during the boom, are now the standard for high net worth separations in 2026. As we look deeper into the mechanics of these settlements, we have to ask, what happens when the boom ends? The strategies that worked when the market was going up 10% a month were suddenly put to the ultimate test when the bubble finally burst. Many of the mediated agreements of the late 90s were built on the assumption of permanent growth. When the reality of a market correction hit, it sent shockwaves through the mediation community and changed the way these deals were structured forever. In the next part, we are going to dive into the specific math of the crash. We will look at how the 2001 dot-com bust and the subsequent real estate volatility forced mediators to invent a whole new set of rules for underwater mortgages and worthless stock options. You will see how the lessons learned during the greatest wealth creation event in history were suddenly applied to the greatest wealth destruction event, and why those who mediated their way through the downturn were the only ones who survived with their credit scores intact. The transition from the exuberance of the late 90s into the volatility of the early 2000s provides one of the most significant case studies in the history of American matrimonial law. When the dot-com bubble burst, the Dow Jones Industrial Average and the Nasdaq didn't just dip. They fundamentally restructured the financial reality of millions of households. In the context of a divorce, this created a mathematical nightmare that traditional litigation was fundamentally incapable of solving in real time. If you were in a courtroom in 2001, you were dealing with a legal system that moved at the speed of paper, while your net worth was evaporating at the speed of fiber optic cables. Imagine a couple we will call Michael and Jennifer living in a high-growth suburb of Austin, Texas. In the year 2001, during the height of the boom in 1999, they had initiated a divorce. At that time, their primary marital asset was Michael's equity in a telecommunications startup, valued on paper at $12 million. They spent 18 months in the discovery phase of a traditional lawsuit, arguing over the fine details of the valuation. By the time they reached their trial date in the spring of 2001, the market had shifted. The company's valuation had plummeted to $800,000. However, the legal fees they had accrued based on the $12 million figure remained fixed. They had effectively spent $300,000 in legal fees to fight over an asset that had lost 90% of its value. This scenario was played out across the United States, and it served as a brutal wake-up call for the legal community. It gave rise to what we now call the dynamic valuation model in mediation. Instead of fighting for a fixed dollar amount based on a static point in time, mediators began encouraging couples to negotiate in percentages and contingent distributions. This allowed the settlement to breathe with the market. In a mediation session, Michael and Jennifer could have agreed to an in-kind distribution of shares rather than a cash buyout. By doing so, they would have both shared in the risk and the potential eventual recovery of the stock, rather than forcing a liquidation at the bottom of the market just to pay off attorneys. The step-by-step evolution of mediation during this downturn focused heavily on the concept of the underwater asset. By 2002, many American couples found that their largest liability was no longer their credit card debt, but their mortgage. The housing market, which had been the bedrock of middle-class wealth, started showing cracks in specific regions. Mediators had to become experts in debt restructuring. The process involved three critical steps that were rarely addressed in a standard courtroom. First, the mediator would facilitate a joint meeting with the mortgage lender to discuss a loan modification or a short sale as part of the divorce decree. Second, they would create a bridge agreement where one spouse stayed in the home to maintain the interest rate and tax benefits while the other moved out, with a predefined trigger date for a future sale. Third, they would negotiate the allocation of the capital loss, which is a concept many litigators at the time didn't even consider. Historical trends from this period show that mediation became the preferred method for handling the 2001 to 2003 recession, because it allowed for private debt negotiation. If you go to court, your financial distress is a matter of public record. For a professional in 2026 looking back, the value of that privacy cannot be overstated. By keeping the negotiation behind closed doors, couples were able to protect their professional reputations and their credit ratings. They could work out a graduated support schedule where alimony payments were tied to the actual performance of a business or a portfolio, rather than a fictional number from a high-earning year that no longer existed. Another major development during this era was the restructuring of retirement accounts, specifically the 401k and the IRA. During the boom, these were seen as reliable, growing pots of gold. After the crash, they became volatile instruments. Mediators began using the Qualified Domestic Relations Order, or QDRO, in more creative ways. Instead of just splitting the account in half, they would analyze the tax-deferred growth potential of specific holdings within the account. For instance, they might allocate the more conservative bond-heavy portion of a 401k to the spouse requiring immediate stability, while the spouse with a longer time horizon until retirement would take the equity-heavy portion. This level of financial tailoring is a hallmark of the masterclass level of mediation that emerged from the ruins of the dot-com era. Consider the case study of a high-net-worth couple in New York City in 2003. They owned a portfolio of real estate and a collection of art that had seen its value fluctuate wildly. In a litigated setting, the court would have ordered an appraisal, which would have cost tens of thousands of dollars and would have been obsolete by the time the judge made a ruling. In mediation, they utilized a collaborative law approach. They hired a single appraiser they both trusted and agreed to a bracketed valuation. If the appraisal came in within a certain range, they had a preset formula for the split. This eliminated the battle of the experts and allowed them to move forward with a degree of certainty in an uncertain world. The 2000s also saw a shift in how child support was calculated in a fluctuating economy. In many U.S. states, child support is a rigid formula based on gross income. But what happens when a high earner's income drops from $500,000 to $80,000 in a single year due to a market correction? Litigation often requires a formal motion for modification, which can take months and thousands of dollars in fees. Mediation during this period introduced the self-adjusting support order. These agreements included clauses that automatically adjusted support levels based on annual tax returns or quarterly earnings statements. This proactive approach prevented the buildup of massive arrears and kept both parents out of the adversarial trap of the family court's enforcement division. What we learn from this retrospective is that the U.S. economic boom created the wealth, but the subsequent bust created the wisdom. The mediation techniques we use today in 2026, the percentage-based distributions, the neutral financial evaluators, and the private debt restructuring sessions, were all forged in the fire of the 2001 crash. It was during this time that the legal profession realized that in a volatile global economy, a static judgment is a liability. The only way to survive a divorce with your assets and your sanity intact was to create an agreement that was as dynamic as the market itself. But there is an even bigger shift on the horizon. As the economy began to recover in the mid-2000s, a new phenomenon began to emerge that would change mediation forever: the rise of the digital asset and the globalized workforce. We were no longer just talking about houses and stocks in a single state. We were entering an era where a couple's assets could be spread across 3 continents and 5 different digital platforms. In the next part, we are going to explore how mediation adapted to the era of globalization. We will look at how mediators handled the first wave of international jurisdictional disputes and the complex tax implications of multi-state property ownership. You will see how the groundwork laid in the early 2000s allowed the most successful families to expand their wealth even as their domestic structures changed, and why the concept of the global divorce mediator became the next big evolution in the industry. As the mid-2000s approached, the U.S. economic landscape shifted from localized wealth to a truly globalized infrastructure. This was the era of the BlackBerry-wielding executive and the rise of the multinational professional family. For the legal system, this presented a jurisdictional nightmare. If a couple lived in New Jersey, worked for a company headquartered in Delaware, held offshore accounts in the Cayman Islands, and owned a vacation property in Cabo San Lucas, which court has the authority to divide those assets? In the traditional litigation model, this often led to a race to the courthouse, where each spouse would file in the jurisdiction they believed offered the most favorable laws, leading to years of expensive jurisdictional battles before a single asset was even discussed. Mediation during this period of globalization provided a vital workaround. Because mediation is a contract-based process rather than a court-mandated one, it allowed couples to bypass the geography wars. They could agree to a private forum where one set of rules, usually based on the laws of their primary residence, would apply to all their global holdings. This prevented the fragmentation of the marital estate. Instead of having 3 different sets of lawyers in 3 different countries, a single mediation team could oversee the entire global portfolio. Imagine a character named Robert, a senior consultant for a global firm in 2005. Robert and his wife, Elena, had spent the last decade moving between London, New York, and Singapore. By the time they decided to divorce, their wealth was a labyrinth. They had a pension from the UK, stock options in a US-based tech firm, and real estate in Singapore. In a court-based scenario, they would have faced the potential outcome of triple litigation. Each country's court might have issued conflicting orders regarding the same pool of money. However, Robert and Elena utilized a specialized form of international mediation that was gaining traction during the boom. Step 1 was the creation of a global asset map. This wasn't just a spreadsheet. It was a comprehensive legal document that identified every asset, its tax home, and its current liquidity. Step 2 involved hiring a mediator, who was also a cross-border tax specialist. This was crucial because moving money across borders during a divorce can trigger massive tax events, or even unintentional violations of anti-money laundering statutes if not handled correctly. One of the most complex historical trends we saw during this era was the valuation of international business interests. During the boom, many Americans were starting businesses that operated entirely online or across multiple borders. These companies often had no physical headquarters, but generated significant revenue. Traditional family court judges often struggled with the concept of a borderless business. Mediators, however, began to use discounted cash flow analyses that accounted for the geopolitical risks of various markets. They would look at the historical trends of the industry and create a buyout structure that protected the business's operational integrity, while ensuring the non-owner spouse received a fair share of the value. In the year 2026, looking back at these cases, we see that the most successful global mediations were those that utilized the 1031 exchange and other tax deferral strategies on an international scale. For example, instead of selling a high-value property in a high-tax jurisdiction, the mediator might facilitate a swap where one spouse takes the property, while the other receives an equivalent value in a more liquid, lower-tax asset. This required a level of creative accounting that the adversarial system simply wasn't designed to accommodate. Globalization also brought the challenge of the trailing spouse in a high-velocity economy. As professionals were moved around the globe to support the expansion of U.S. companies, many spouses put their own careers on hold. In a mediation session in 2006, the conversation wasn't just about current bank balances. It was about the loss of human capital. Mediators began to incorporate career reentry counseling into the settlement process. They would look at the historical data of a spouse's earning potential before the international moves and negotiate for a lump sum payment specifically earmarked for advanced education or business startup costs. This was a more holistic approach to equitable distribution that aimed to restore the economic parity of both parties. The data from the U.S. Census Bureau during this period showed a significant increase in international marriages and, consequently, international divorces. This led to the development of the International Social Service or ISS network, which mediators used to coordinate child custody across borders. Imagine a scenario where one parent wanted to move back to their home country in Europe, while the other stayed in the U.S. In litigation, this often resulted in a winner-takes-all relocation trial that could last years and cost hundreds of thousands of dollars. In mediation, these families worked out virtual visitation schedules and travel cost-sharing agreements that prioritized the children's stability over a legal victory. They used the booming technology of the time, early video conferencing and international flight hubs, to create a functional two-country parenting plan. Another key component of the globalized mediation masterclass was the management of currency risk. During the mid-2000s, the US dollar saw significant fluctuations against the euro and the yen. If a settlement agreement was signed in January, but the actual transfer of funds didn't happen until June, the value of that transfer could change by 5 or 10%. Mediators began to insert currency stabilization clauses into agreements. These clauses would peg the value of the distribution to a specific exchange rate or a basket of currencies to ensure that the purchasing power of the settlement remained consistent, regardless of market volatility. This was also the era when the concept of the private judge began to overlap with mediation. In high-stakes cases, couples would hire a retired judge to act as a private mediator arbitrator. This person had the authority of the court but worked on the couple's timeline in a private office. This was the ultimate wealth preservation move for the elite. It allowed them to have the certainty of a legal ruling without the public exposure or the delays of the state court system. These private proceedings often involved the most complex financial instruments of the boom, including hedge fund interests and private equity carry. As we analyze these historical trends, it becomes clear that mediation was no longer just a way to settle a divorce. It was a sophisticated financial tool used to manage the complexities of a globalized life. The people who chose mediation were often the ones who understood that the old systems of law were being outpaced by the new systems of wealth. They saw that the traditional court was a blunt instrument being used on a surgical problem. However, as the global economy became more interconnected, a new and unexpected variable entered the room. It wasn't just about money and houses anymore. It was about the very data that defined our lives. We were entering the age of the digital footprint. This era introduced a whole new set of assets that no one knew how to value, or even find. We are talking about the early days of digital intellectual property, domain names that were worth millions, and the first whispers of decentralized finance. In the next part, we are going to look at the digital revolution's impact on the mediation room. We will explore how mediators began to handle the division of invisible assets and the emergence of the digital forensic mediator. You will see how the fight over the family home was replaced by the fight over the family server, and why the privacy of mediation became the only defense against the growing threat of digital exposure during a high-profile split. The move into the virtual world changed the stakes of divorce mediation forever, and the way it was handled in the late 2000s set the stage for the massive digital asset battles we are seeing today in 2026. The late 2000s marked the dawn of the digital asset frontier, a period where the tangible world of real estate and physical gold began to merge with the intangible world of bits and bytes. In the context of the American economic boom, this transition created a massive blind spot in the traditional legal system. Judges across the United States were still struggling with the concept of email discovery, while the most forward-thinking couples were already building empires in domain names, early e-commerce platforms, and digital intellectual property. This was the era where the mediation room became a high-tech laboratory for the division of invisible wealth. Imagine a character named Marcus in 2007. Marcus was an early adopter who had spent the better part of the boom years acquiring three-letter domain names and developing a series of niche affiliate marketing websites. To the average divorce attorney in a suburban court, Marcus looked like a man with a modest income and a hobby. However, in reality, those domain names were the 21st century equivalent of beachfront property. In a traditional litigated divorce, a court-appointed appraiser might have valued Marcus's digital portfolio at the cost of registration. Pennies on the dollar. But in a mediation setting, Marcus and his spouse, Sarah, could bring in a digital asset specialized consultant. This expert wouldn't just look at the current bank balance. They would analyze the traffic metrics, the search engine optimization value, and the historical trends of the domain's secondary market. Through mediation, they were able to reach a potential outcome that recognized the future earning capacity of these assets. They crafted a settlement where Sarah received a percentage of the future ad revenue generated by the sites for a set period, rather than a forced liquidation at a time when the market didn't even fully understand what a domain was worth. This prevented a catastrophic loss of value that would have occurred if a judge had simply ordered the sale of the digital business to the highest bidder on the courthouse steps. The step-by-step process of digital mediation in the late boom era required a new level of forensic transparency. Step 1 was the digital audit. This involved identifying all accounts, including those that didn't appear on a traditional bank statement, early payment processors like PayPal, digital storefronts on eBay or Amazon, and even high-value virtual items in early gaming metaverses like Second Life or World of Warcraft. Step 2 was the access protocol. Because digital assets are often tied to a single set of credentials, the mediator had to facilitate the transfer of administrative rights or the creation of joint access tokens to ensure that neither party could ghost the other by changing a password. Step 3 was the valuation of user data. Even back in 2008, mediators were beginning to realize that a customer mailing list of 100,000 verified names had a distinct, quantifiable value in a divorce settlement. Historical trends show that this period also introduced the concept of the social media prenup and the digital privacy agreement within the mediation framework. As MySpace and Facebook began to dominate the American social landscape, the potential for digital revenge became a real legal threat. Mediation sessions started to include clauses that governed what could be posted about the divorce online. These weren't just be nice agreements, they included liquidated damages clauses. If one party posted disparaging remarks or shared private financial data on a social platform, they would forfeit a specific portion of their settlement. This was a direct response to the viral nature of the new internet, providing a level of protection that the slow-moving courts could not offer through traditional gag orders. Consider the case study of a Silicon Valley couple in 2009. The husband was a software engineer who had authored several pieces of open-source code that were being integrated into larger corporate frameworks. The wife was a digital strategist. In litigation, the question of whether code was a marital asset or personal intellectual property would have been a 5-year battle ending in a Supreme Court appeal. In mediation, they used a royalty-sharing model. They treated the code like a songwriter treats a hit record. They established a baseline of current utility and agreed that any future licensing deals or acquisitions involving that specific codebase would be shared on a 60-40 basis for the next decade. This allowed the innovation to continue without the chilling effect of an active lawsuit. The economic boom's peak also coincided with the massive expansion of the 529 college savings plan. As the cost of education skyrocketed, American families poured billions into these tax-advantaged accounts. However, 529 plans are technically owned by one individual for the benefit of another. In a divorce, this created a massive risk of asset diversion. A parent could, in theory, change the beneficiary or withdraw the funds, albeit with a penalty. Mediators during this period developed the Joint Stewardship Agreement. They transformed the 529 plan from a single-owner asset into a dual-signature account, or they negotiated the transfer of the account to a neutral third-party trustee. This ensured that the wealth built during the boom was preserved for the next generation, regardless of the parent's marital status. Another deep-dive element of this era was the division of executive perks. During the height of the corporate boom, compensation wasn't just about salary and bonuses. It was about private jet hours, country club memberships, and executive health suites. These were non-transferable assets that had significant lifestyle value. Mediators had to find a way to monetize these perks for the non-executive spouse. For example, if a husband had 100 hours of private jet time through his firm, the mediator might calculate the commercial equivalent value of those hours and award the wife an offsetting credit in the division of the home equity. This prevented a lifestyle cliff, where one spouse continued to live in the boom-era luxury, while the other was relegated to commercial travel and public gyms. As we move into 2026, we see that these 2000s-era mediation strategies were the precursor to how we now handle even more complex assets. The way a 2008 mediator handled a domain name is exactly how a modern mediator handles a decentralized autonomous organization or a portfolio of generative AI licenses. The core principle remains the same. In a rapidly evolving economy, the value is in the future potential, not just the past cost. The end of the boom, however, brought a final crushing challenge to the mediation world. As the 2008 financial crisis began to loom, the wealth that everyone was dividing started to turn into toxic debt. The conference rooms that were once filled with discussions about stock options were suddenly filled with discussions about foreclosures and insolvency. The masterclass in mediation was about to enter its most difficult phase: the art of dividing nothing. When the music stopped in 2008, the mediation industry had to pivot from being a tool for wealth distribution to a tool for survival. You are about to see how the most successful mediators in America managed to keep families from total bankruptcy by using the same negotiation tactics they had once used to build fortunes. The transition from the height of the boom to the depths of the Great Recession forced a radical redesign of the American settlement, and the lessons learned in those dark rooms are the only reason many of the wealthiest families today still have a foundation to stand on. In the next part, we are going to break down the specific mechanics of the negative equity mediation. We will look at the exact scripts and strategies used to negotiate with banks during a divorce, the rise of the short sale settlement, and how the collapse of the housing market created a new class of divorce nomads who had to mediate their way across state lines just to find a job. The boom was over, and the era of the economic divorce rebuild had begun. The year 2008 remains etched in the American psyche as the moment the music stopped, but for those in the middle of a divorce mediation, it was more like the floor falling out from a skyscraper. As we look back from the vantage point of 2026, the transition into the Great Recession provides the most harrowing and educational chapter of our masterclass. This was the era of the negative equity mediation, where the goal shifted from dividing the spoils of a boom to the surgical allocation of debt and shared loss. In previous years, a mediator's job was to help a couple decide who gets the beach house. In 2008 and 2009, the mediator's job was to figure out how to keep both parties from falling into a decade-long financial abyss when that same beach house was worth $400,000 less than the mortgage. Imagine a character named Thomas, a construction project manager in Florida, and his spouse, Amanda. In 2006, at the height of the housing frenzy, they had used their boom-time earnings to purchase a suburban home for $700,000 with a 5% down payment. By early 2009, the appraisal came back at $420,000. They were $280,000 underwater. In a traditional court setting, a judge might simply order the house to be sold, but in 2009 there were no buyers, and a forced sale would result in a massive deficiency judgment that would haunt both of them for the rest of their lives. Thomas and Amanda turned to a new breed of recession-era mediation. The step-by-step strategy they used is now a standard historical case study for handling insolvency in matrimonial law. Step 1 was the tri-party negotiation. The mediator didn't just facilitate a conversation between Thomas and Amanda. They brought in a short sale specialist to negotiate directly with the bank. The goal was a potential outcome where the bank would agree to accept the current market value as payment in full, waiving the right to pursue Thomas or Amanda for the remaining balance. This required a level of cooperation that is impossible in an adversarial courtroom, where spouses are busy blaming each other for the original purchase. Step 2 involved the creation of a debt offset ledger. Since the house was a liability, the mediator looked for liquid assets to balance the scale. If Thomas wanted to keep his 401k intact, he had to take on a larger share of the unsecured credit card debt they had accumulated while trying to stay afloat as the construction industry cratered. Step 3 was the contingency clause. They drafted an agreement that stated if the house couldn't be short-sold within 6 months, they would pivot to a deed in lieu of foreclosure, with specific language protecting Amanda's credit score because she was the one with the higher earning potential in the new, post-crash economy. Historical trends during this period show that the mediation room became the only place where the human element of the crash was recognized. While banks were treating people like numbers, mediators were helping couples like Thomas and Amanda understand that their financial survival depended on mutual protection. If one spouse went bankrupt, it often triggered cross-default clauses in joint loans, dragging the other spouse down with them. Mediation in 2026 still uses these survival blueprints. We see this today when couples deal with volatile tech valuations. They learn that protecting the other person's credit is actually a form of self-interest. The era of the divorce nomad also began during this downturn. As the U.S. unemployment rate climbed toward 10%, many individuals found that the only way to secure a new job was to move across state lines. In a traditional divorce decree from the boom years, there were often strict geographic restrictions that prevented a parent from moving more than 50 miles away. In 2009, these restrictions became a trap. If you couldn't move to where the work was, you couldn't pay child support. Consider the case study of a family in Michigan, the heart of the automotive crisis. The father, an engineer, lost his job and found a new position in South Carolina. The mother, a teacher, was tied to the Michigan home that wouldn't sell. In a litigated setting, a relocation battle would have cost $50,000 and taken a year. In mediation, they crafted a bridge parenting plan. This was a sophisticated 3-year transition model. For the first 18 months, the children would stay in Michigan with the mother to finish school, with the father paying a higher percentage of travel costs in lieu of a portion of cash support. Once the Michigan home finally reached a break-even point and could be sold, the mother would relocate to South Carolina, and they would return to a more traditional shared custody schedule. This flexibility allowed the father to accept the job immediately, ensuring the family's total income didn't drop to zero. The psychological masterclass here is the shift from the abundance mindset to the scarcity mindset. In the 90s, mediation was about optimizing gains. In the late 2000s, it was about mitigating damage. Mediators began using what is known as the zero-sum reconciliation. They would lay out the absolute minimum requirements for each party to remain housed, fed, and employed. Any asset that didn't contribute to those 3 pillars was liquidated or surrendered. This was a brutal process, but data suggests that couples who mediated through the 2008 crash had a significantly higher rate of long-term financial recovery than those who let a court decide their fate. A judge doesn't care if a credit score is destroyed by a judgment. A mediator does, because they know that credit is the lifeblood of the American rebuild. We also saw the rise of the internal family loan during this period. With traditional banks refusing to lend, mediators helped couples look toward their extended families. Imagine a scenario where a husband's parents lent the couple $50,000 during the boom to renovate a kitchen that was now worth nothing. In a divorce, is that a gift or a loan? Litigation would spend $10,000 in legal fees to answer that question. Mediation allowed the couple to structure a repayment plan that treated the debt as a shared marital liability, often negotiating a lower interest rate or a longer term with the in-laws in exchange for other concessions in the divorce. As we move toward the end of the recession era in our retrospective, we see that the legal landscape had been permanently altered. The boom had taught us how to divide wealth, but the bust taught us how to manage risk. This period introduced the concept of the clawback and the sunset clause in ways we hadn't seen before. If a husband was giving up his interest in a business that was currently valued at near zero, he would negotiate a sunset clause. If the business was sold for more than $1 million within the next 5 years, the ex-wife would receive a catch-up payment. This was a way of acknowledging that the current market was irrational and ensuring that both parties would eventually benefit if the U.S. economy rebounded. This era also forced a radical rethink of the retirement age. During the boom, people planned to retire at 55. After 2008, the median retirement age in mediated agreements jumped to 67 or 70. Mediators had to help couples rework 20 years of financial projections in a single afternoon. This led to the development of the silver divorce strategies, specifically focused on Americans over the age of 50, who were divorcing with significantly diminished portfolios. The lessons of 2008 are the foundation of modern mediation in 2026 because they proved that the process could survive the worst economic conditions imaginable. It proved that mediation wasn't just a fair-weather tool for the wealthy. It was a rugged, adaptable system for the middle class to survive a catastrophe. But as the economy finally began to heal in the early 2010s, a new and unexpected force was gathering strength. The recovery wasn't just about going back to the old way of doing things. It was the beginning of the gig economy and the age of decentralized income. The people mediating their divorces in 2012 and 2013 were no longer just W-2 employees. They were freelancers, consultants, and founders of companies that didn't exist 2 years prior. This created a massive challenge. How do you calculate support and divide assets when someone's income changes by 50% every month? In the next part, we are going to look at the rise of the fluctuating income model. We will explore how mediation adapted to the Uberification of the American workforce and the complex world of the 1099 divorce. You will see how the strategies for managing instability became the new normal, and why the fixed monthly payment became an obsolete relic of the boom years. The world was moving faster than ever, and the mediation room was the only place keeping up. As the U.S. economy began its slow, grinding recovery in the early 2010s, the traditional landscape of American employment underwent a fundamental transformation. We moved away from the era of the lifelong corporate salary and into the age of the diversified income stream. For the mediation world, this was the dawn of the 1099 revolution. In the previous decades of the boom, determining child support or alimony was a relatively straightforward exercise in looking at a W-2. But as the gig economy and independent consulting became the primary drivers of middle-class recovery, the old formulas broke. This period forced mediators to invent what we now call the fluctuating income model, a system designed to handle the reality that for millions of Americans, every month is a different economic weather pattern. Imagine a character named Kevin in 2013. Kevin was a former corporate marketing director who, after the 2008 crash, pivoted into high-end freelance consulting. His income was no longer a steady check. It was a series of peaks and valleys. One month he might land a $30,000 contract with a tech startup, and the next 3 months he might earn nothing while pitching new business. Kevin and his spouse, Lisa, were navigating a divorce during this transition. In a traditional courtroom, a judge would likely look at Kevin's highest earning year and set a fixed monthly support obligation based on that number. This is a recipe for financial disaster. If Kevin had a slow quarter, he would quickly fall into arrears, facing legal penalties and potential license suspension. Despite having no actual liquid cash, mediation provided the only logical solution to this modern American problem. The step-by-step strategy developed for Kevin and Lisa focused on the creation of the percentage-based true-up. Step 1 was establishing a low sustainable floor. They agreed on a base monthly support amount that Kevin could pay even during his leanest months. Step 2 involved the bonus trigger. Whenever Kevin received a payment above a certain threshold, a pre-negotiated percentage of that specific check was automatically diverted to Lisa as supplemental support. Step 3 was the annual reconciliation or the true-up. At the end of the tax year, their mediator would sit down with their respective 1099s and tax returns to ensure the total paid matched the agreed-upon percentage of Kevin's actual net profit, rather than his gross revenue. Historical trends from this era show that this model saved thousands of families from the cycle of litigation and enforcement. It recognized that in a post-boom economy, cash flow is more important than paper net worth. This was also the period where the definition of an asset began to blur with the definition of a job. Consider the rise of the social media influencer, or the digital content creator during the early 2010s. If a couple started a YouTube channel together that generated $50,000 a year in ad revenue, is that a business to be divided or a job to be shared? In one landmark case study from 2014, a mediating couple in Southern California faced this exact dilemma. They had built a lifestyle brand around their family's travels. In a litigated divorce, the court would have struggled to value the brand. Would they sell the channel? How do you split a personality? The mediator facilitated a creative operational agreement. The couple agreed to continue co-owning the digital entity as a business partnership. They drafted a strict content schedule where each parent had specific filing days and a clear division of the back-end revenue. This allowed them to preserve the asset's value, which would have vanished if they had stopped posting, while maintaining their separate lives. This was the birth of the co-parenting corporate charter, a document that treated the family's digital presence as a professional enterprise with its own bylaws and dispute resolution triggers. As we look back from 2026, we also see how this era revolutionized the treatment of healthcare and divorce settlements. During the boom, healthcare was an afterthought. Most professionals had robust employer-sponsored plans. But as the gig economy grew and the Affordable Care Act was implemented, the cost and complexity of maintaining separate health insurance became a primary negotiation point. Mediators began to use the Health Savings Account or HSA as a strategic bargaining chip. They would negotiate who would maintain the family deductible and how the tax-free funds within the HSA would be allocated for the children's future orthodontic or mental health needs. This level of granular health wealth planning was entirely absent from the litigation of the 1990s, but became a cornerstone of the 2010s mediation masterclass. Another deep dive element of the 1099 divorce was the valuation of the home office. As more Americans began working from home, the family residence became a mixed-use asset. In a mediation session, a couple had to decide how to handle the mortgage interest deduction when one spouse was using 25% of the square footage for a primary business. Step by step, the mediator would work with a CPA to determine the tax benefit sharing ratio. If the husband stayed in the house and claimed the business deduction, the wife would receive a corresponding credit in the division of the liquid savings. This ensured that the tax advantages of the boom-era house were equitably distributed, even if only one person remained on the deed. We also saw the emergence of the education as alimony trend. In a volatile economy, the best way to ensure a spouse's future financial independence isn't a monthly check. It's a skill set. Instead of traditional spousal support, many mediated agreements in the mid-2010s included a tuition transfer. One spouse would agree to pay for the other's master's degree or coding bootcamp in exchange for a shorter duration of cash payments. This was a forward-looking strategy that benefited both parties. The payer limited their long-term liability, and the payee gained a high earning potential that couldn't be taken away by a market crash. The data from the U.S. Bureau of Labor Statistics during this time showed a massive shift toward contingent work. This meant that mediation had to become more frequent and less expensive. This led to the rise of the mediation check-in. Instead of a one-time event that ended with a final decree, couples started building review triggers into their agreements. If income shifted by more than 20%, or if a new business venture was launched, they would return to the mediator for a 2-hour tune-up, rather than filing a motion in court. This kept the legal costs low and the cooperation high, a stark contrast to the scorched-earth tactics of the previous generation. This era of instability and innovation proved that the American family was more resilient than the legal system gave it credit for. By treating divorce as a complex business restructuring rather than a moral failure, mediation allowed people to navigate the transition into the modern economy without losing everything they had spent the boom years building. It turned the accidental millionaires of the 90s into the intentional entrepreneurs of the 2010s. But as the 2010s progressed, a new asset class began to move from the fringes of the internet into the center of the mediation room. It was something that didn't exist in the 90s, was worth pennies in 2010, and by 2017 was creating a new class of crypto millionaires. The volatility of this new asset would make the dot-com bubble look like a walk in the park, and it would present the greatest challenge to the concept of full disclosure that the mediation industry had ever seen. In the next part, we are going to dive into the high-stakes world of the crypto divorce. We will explore the digital treasure hunt that mediators have to conduct, the legal complexities of cold storage wallets, and the revolutionary ways that blockchain technology is actually being used today in 2026 to create self-executing divorce settlements. You will see how the fight over the hidden offshore account has been replaced by the fight over the private key, and why the forensic crypto mediator is now the most sought-after professional in the industry. The boom was back, but this time it was decentralized and encrypted. The entry of cryptocurrency into the American household shifted the mediation landscape from a battle of spreadsheets to a high-stakes digital treasure hunt. By 2017, the second major boom of the 21st century was in full swing, but unlike the stock market surge of the 90s, this wealth was often invisible, volatile, and encrypted. This period introduced a fundamental crisis of trust in the mediation room. In a traditional divorce, you could subpoena a bank or a brokerage. In the world of decentralized finance, if one spouse holds the private keys to a hardware wallet and refuses to disclose them, the legal system faces a technological wall that no court order can easily scale. Imagine a character named Jason in 2017, a software developer who had been mining Bitcoin since 2012. Jason and his spouse, Michelle, decided to divorce at the exact moment the crypto market was hitting record highs. Jason claimed he had lost his seed phrases in a hard drive failure, a common narrative that mediators began to hear with suspicious frequency. In a traditional litigated setting, Michelle's attorneys would have spent six figures on forensic computer experts to try and recover data that might not even exist. The potential outcome in court would likely have been a stalemate. As a judge cannot order the distribution of an asset they cannot prove exists. Mediation in the crypto era forced the development of the Digital Integrity Protocol. Instead of an adversarial hunt, the mediator facilitated a step-by-step disclosure process centered on tax records and lifestyle analysis. Step 1. The mediator worked with the forensic accountant to perform a lifestyle audit. If Jason's reported income was $80,000, but he was driving a brand new Tesla and paying off a mortgage early, the math pointed to an undisclosed capital source. Step 2. The mediator utilized blockchain explorers to track public wallet addresses associated with Jason's known accounts. Step 3. The incentive-based settlement. Rather than threatening Jason with contempt of court, the mediator crafted a deal where Jason received a larger share of the tangible real estate in exchange for a full, transparent disclosure and an in-kind transfer of a portion of the crypto assets to Michelle. This prevented a total loss of the assets' value through legal fees and ensured both parties could benefit from the ongoing market expansion. Historical trends during this period show that the volatility of these assets required a new kind of legal drafting: the price action contingency. In 2017, Bitcoin could swing by 20% in a single afternoon. If a couple mediated a settlement on a Tuesday based on a valuation of $15,000 per coin, and the actual transfer didn't happen until Friday when the price was $10,000, one party was being severely disadvantaged. Mediators began to mandate that all crypto transfers be executed in percentages of the total coins held, rather than a dollar-denominated value. This ensured that both parties shared the market risk from the moment of the agreement to the moment of the transfer. Consider a case study from 2019 involving a high-net-worth couple in Miami. The husband held a significant portfolio of Ethereum and several early non-fungible tokens. The wife was a traditional investor. In mediation, they faced the challenge of tax liability. Every time crypto is transferred or liquidated, it triggers a capital gains event. The mediator brought in a tax neutral who specialized in the 2017 Tax Cuts and Jobs Act. They structured a potential outcome where the husband retained the crypto, but assumed 100% of the future tax liability, giving the wife a corresponding larger share of the cash savings which carried no future tax burden. This allowed the husband to keep his high-risk, high-reward assets while providing the wife with the immediate liquidity she valued. As we look at the data from 2026, we see that the most revolutionary development born from this era was the smart contract divorce decree. We are now seeing the first generation of mediated agreements that are coded directly onto a blockchain. In these cases, the mediation process ends with the creation of an escrow wallet. The husband and wife each hold a key, and a neutral third party holds the third. When certain conditions are met, such as the finalization of the divorce or the sale of a property, the smart contract automatically executes the distribution of funds. This eliminates the need for post-divorce enforcement and reduces the risk of one party hiding assets after the agreement is signed. The crypto boom also expanded the definition of what constitutes a marital asset to include digital intellectual property like social media handles and domain names, which we touched on previously, but now with the added layer of decentralized ownership. If a couple co-managed a decentralized autonomous organization or DAO, the mediator had to figure out how to split voting rights. This led to the development of the proxy parenting agreement, where one spouse might retain the economic benefit of the tokens, while the other retained the voting rights to ensure the business continued to function. Another deep dive element of this era was the impact of the 2020 economic shift. As the world moved toward remote work, the physical location of the mediation room disappeared. The US became a hub for virtual mediation. This wasn't just about using Zoom, it was about the security of the data being shared. mediators began using encrypted data rooms and multi-factor authentication for all financial disclosures. This increased the speed of the process significantly. A couple could now mediate a complex, multi-million-dollar divorce in 3 weeks because they no longer had to wait for physical documents to be mailed or for court dates to open up. The historical trends suggest that virtual mediation increased the settlement rate by nearly 15% compared to in-person sessions. Why? Because the psychological barrier of being in the same room as an ex-spouse was removed, allowing both parties to focus strictly on the financial engineering. In the fast-paced economy of the early 2020s, this efficiency was paramount. Couples in 2026 now view virtual mediation as the default, a legacy of the period when the world had to learn how to negotiate at a distance. But as the wealth became more digital and the process became more virtual, a new human crisis began to emerge. The sheer complexity of these modern settlements started to take a toll on the emotional well-being of the families involved. The wealth was there, but the peace was missing. This led to the final evolution of our retrospective, the rise of the holistic mediation model. This is where the financial masterclass meets the psychological masterclass. The most successful settlements of the late 2010s weren't just the ones that divided the Bitcoin correctly. They were the ones that addressed the human capital of the family. We began to see the integration of co-parenting coordinators and divorce coaches directly into the mediation team. This prevented the financial success, personal failure outcome that had plagued the boom-era divorces of the 90s. In the next part, we are going to explore the intersection of high-stakes finance and emotional intelligence. You will see how the most elite mediators in the US are now using behavioral economics to get deals done when the math alone isn't enough. We will look at the nudge theory, applied to divorce, and why the most expensive asset in any divorce isn't the house or the crypto. It's the future mental health of the children. We are moving into the final stages of our masterclass, where we reveal how the lessons of 3 decades of economic booms and busts have been distilled into a single, unified strategy for the 2026 landscape. The integration of behavioral economics into the mediation room marked the final sophisticated layer of the American divorce evolution. By the early 2020s, the industry realized that while the math of the boom was complex, the humans calculating it were even more so. This transition birthed the holistic mediation model, a framework that recognizes that financial logic is often hijacked by cognitive biases. In a retrospective look from 2026, we see that the most effective settlements were not just those with the best tax structures, but those that utilize nudge theory to guide parties toward rational self-interest. Imagine a character named Sarah, a high-performing surgical consultant, and her husband, Mark, who stayed home to raise their 3 children during the post-2010 tech surge. Their marital estate was valued at $15 million, including significant restricted stock units and a primary residence in a high-demand zip code. Despite the clear financial data, the mediation was stalled for months. Why? Because Mark was suffering from the endowment effect, a behavioral bias where an individual overvalues an asset simply because they own it. To Mark, the family home wasn't just real estate, it was his identity. In a traditional court, a judge would have likely ordered the house sold to achieve equitable distribution, ignoring the psychological fallout. The mediator in this 2022 case study utilized a step-by-step behavioral intervention. Step 1: decoupling. The mediator separated the emotional value of the home from its financial utility by introducing a neutral third-party appraiser who provided a range of potential outcomes based on historical trends of the local market. Step 2: choice architecture. Instead of asking Mark if he wanted to sell the house, the mediator presented 3 distinct financial packages. Package A involved keeping the house but sacrificing a significant portion of the liquid retirement accounts. Package B involved selling the house and creating a massive educational trust for the children. Package C involved a deferred sale. By framing the decision as a choice between structured futures rather than a loss of the past, the mediator nudged Mark toward Package B, which ultimately provided the most long-term stability for the family. This era also saw the rise of the divorce coach as a formal member of the mediation team. Unlike a therapist, the coach's role was strictly tactical. They worked with parties to manage the cognitive load of the mediation. Data from US-based mediation centers in the early 2020s indicated that when a divorce coach was involved, the time to reach a final agreement decreased by 22%. This is because the coach helped individuals move past the sunk cost fallacy, the tendency to continue a legal fight simply because they had already invested so much money and time into it. By addressing the emotional fatigue early, mediation preserved the assets that would have otherwise been incinerated in a prolonged court battle. Historical trends during this period also highlight the importance of the social capital valuation. For the first time, mediators began to quantify the value of professional networks and reputation. In a high-stakes U.S. market, your LinkedIn connections and industry standing are as much an asset as your bank account. If a divorce becomes public and messy, the damage to that social capital can lead to a 30 to 40% drop in future earning potential. Mediators use this data to encourage private settlements. They framed the non-disclosure agreement not as a way to hide secrets, but as a wealth preservation strategy for both parties. If the brand of the family remained intact, the future revenue streams remained secure. Step by step, the mediation process in 2026 now incorporates a pre-mediation financial literacy phase. This was a lesson learned from the disparities of the 90s boom. To ensure a level playing field, the mediator provides both parties with a crash course in the specific assets they are dividing. Whether it is the mechanics of a QDRO or the tax implications of a 1031 exchange. This reduces the information asymmetry that often leads to one party feeling coerced or cheated. By the time they reach the negotiation table, both Mark and Sarah understand the why behind the numbers, which drastically reduces the likelihood of future litigation to modify the agreement. We must also look at the impact of the 2020 to 2024 inflation spike on mediation drafting. During the boom years, a fixed alimony payment of $5,000 a month might have seemed generous. But as the cost of living in the U.S. surged, that fixed amount lost significant purchasing power. Mediators responded by reviving and refining the cost of living adjustment or COLA clause. These clauses, tied to the Consumer Price Index, ensured that the support payments stayed relevant to the economic reality. This was a masterclass in future-proofing. Instead of a static decree, the agreement became a living document that accounted for the inherent volatility of the US dollar. Consider another scenario. A couple with a small but rapidly growing e-commerce business. In 2023, the business was valued at $2 million, but the growth trajectory suggested it could be worth $10 million by 2026. Litigation would have forced a valuation at the date of trial, likely resulting in one spouse being bought out at a price that would look like a pittance 3 years later. Mediation allowed for the creation of an earn-out provision. The non-operating spouse agreed to a lower immediate buyout in exchange for a percentage of the gross revenue over the next 36 months. This turned the divorce settlement into a performance-based investment, aligning the interests of both parties even after the marriage ended. The data supports this shift toward collaborative financial engineering. A 2025 study of U.S. matrimonial outcomes showed that mediated agreements incorporating earn-outs and COLA clauses had a 90% lower rate of post-judgment disputes. This is the definition of a high-retention legal strategy. By building flexibility into the core of the contract, mediation replaced the rigid justice of the courtroom with the practical utility of a business merger. Furthermore, we saw the emergence of the multi-generational mediation. As the baby boomer generation began to pass down the largest transfer of wealth in American history, divorcing couples in their 40s and 50s had to account for expected inheritances. Since inheritance is generally considered separate property in the U.S., mediators had to help couples navigate the commingling traps. They used step-by-step tracing to identify which boom-era assets were truly joint and which were separate, preventing the accidental forfeiture of family legacies. They created bloodline trusts within the divorce decree, ensuring that even if a parent remarried, the wealth accumulated during the first marriage would eventually pass to the children of that union. As we stand in 2026, the holistic mediation model has become the apex of the industry. It is no longer just about the division of property, it is about the transition of a family system. We have moved from the War of the Roses era of the 80s and 90s into an era of strategic realignment. The most successful individuals in the U.S. today don't view divorce as the end of their financial life, but as a complex corporate spin-off. They understand that the goal isn't to beat the other person, but to exit the partnership with the maximum amount of resources and the minimum amount of damage. But even with all this sophistication, there is one final piece of the puzzle. As we move into our concluding chapter, we have to look at the post-divorce rebuild. Dividing the assets is only half the battle. The true test of a boom-era mediation is how well the parties are positioned to grow their wealth in the years that follow. We are going to look at the second-act strategies used by the most successful divorcees in America to turn their settlement into a springboard for even greater prosperity. In the final part of our deep dive masterclass, we will reveal the specific investment blueprints used by those who mediated their way to the top. We will examine how the mediation generation is redefining retirement, legacy, and new partnership agreements. This is the ultimate guide to not just surviving the end of a marriage, but thriving in the new American economy. The final loop is about to be closed, and it involves a secret that the traditional legal system has been trying to hide for decades. The secret that the traditional legal system has worked so hard to obscure is quite simple. Litigation is a wealth destruction engine, while mediation is a wealth preservation platform. In this final chapter of our retrospective, we are looking at the second act strategies of the individuals who walked out of the mediation room and into a future of compounding prosperity. As we stand in 2026, the data is undeniable. Those who chose the path of collaborative negotiation during the various U.S. economic cycles have a significantly higher net worth today than those who chose the path of the courtroom. This isn't a coincidence. It is the direct result of the specific post-divorce rebuild strategies that only mediation allows. Imagine a character named David, who in 2021 was a senior executive at a renewable energy firm. When David and his spouse, Karen, divorced, they had a marital estate of $8 million. In a litigated scenario, that estate would have been frozen for 2 years, liquidated at a fixed point in time to pay legal fees and split the remainder, and both parties would have started their new lives with a diminished capital base and significant psychological trauma. Instead, David and Karen used a mediation blueprint that prioritized capital velocity. They reached an agreement in 60 days. By settling quickly, they avoided the massive opportunity cost of the litigation delay. David was able to reinvest his share of the assets into the burgeoning 2022 to 2024 green energy sector, while Karen used her settlement to launch a boutique consulting firm that capitalized on the post-pandemic remote work trend. The first pillar of the second act strategy is the liquidity launchpad. In a mediation, you have the power to structure the distribution of assets based on your specific future goals. Step 1. The cash flow audit. David and Karen didn't just split everything down the middle. Karen needed high liquidity to start her business, so she took a larger share of the savings and money market accounts. David, who had a high salary, took the illiquid stock options and the commercial real estate interests. Step 2. The tax efficiency shield. By keeping the assets in their respective tax-advantageous buckets, they avoided the forced liquidation penalties that a judge might have triggered. Step 3. The reinvestment clause. They included a provision that allowed for the joint management of certain long-term assets until a specific market milestone was hit, ensuring they both benefited from the eventual peak of the market. Historical trends from the last decade show that this flexibility is the primary driver of post-divorce success. We see a recurring case study in the tech hubs of the U.S., from Seattle to Raleigh. High-earning professionals who mediate their divorces tend to maintain their professional focus. In contrast, those in litigation often see a decline in job performance, missed promotions, and even job loss due to the extreme stress and time commitment of a court battle. By 2026, the term legal burnout has become a recognized economic drag. Mediation acts as a preventative measure against this burnout, allowing the human capital of both spouses to remain at peak performance during the most critical rebuilding years of their lives. Another deep dive element of the rebuild is the credit score sanctuary. During the mediation process, a couple can work together to retire joint debts in a way that maximizes both of their credit profiles. This is nearly impossible in litigation, where the focus is on blaming the other party for the debt. In the current 2026 credit environment, where interest rates are a primary factor in investment viability, having a 780 credit score versus a 620 credit score can mean the difference of hundreds of thousands of dollars in lifetime interest costs on a new mortgage or a business loan. Mediators facilitate the debt cure strategy, where assets are specifically allocated to pay off high-interest joint liabilities before the final decree is signed, giving both parties a clean, high-scoring start. Let's look at the step-by-step legacy plan that has emerged as the gold standard for high-net-worth mediation in 2026. This involves the creation of the family private bank. In these sophisticated mediated settlements, the parents don't just divide the wealth. They set aside a portion of the marital estate into a jointly managed trust for the children. This trust acts as an internal lender for the children's future business ventures, home down payments, or education. By doing this, the parents move from being adversaries to being the co-trustees of their children's future. This prevents the intergenerational wealth leakage that typically occurs during a messy divorce, where the next generation's inheritance is consumed by the parents' legal bills. The data from the U.S. Financial Planning Association suggests that these mediated trusts have a 40% higher success rate in preserving family wealth over 3 generations than traditional inheritances. This is the ultimate retrospective lesson of the boom. Wealth isn't just about what you have, it's about the structures you build to keep it. Mediation allows for the construction of these structures during the most volatile transition a family will ever face. Imagine a scenario where a couple in 2026 is looking at their historical trends. They see that by mediating they save $200,000 in legal fees. If they invest that $200,000 at a 7% annual return in 20 years, that money grows to nearly $800,000. That is the mediation dividend. It is a tangible, quantifiable amount of wealth that simply doesn't exist for the couple that goes to court. This is the math that the traditional legal industry doesn't want you to do. They want you to focus on the win in the courtroom, while the mediator focuses on the wealth in your bank account 20 years from now. Furthermore, we must address the rise of the prenuptial mediation. As the mediation generation enters their second and third marriages, they are using the same techniques to build their prenuptial agreements. They aren't viewing prenups as a lack of trust, but as a sophisticated business plan for their union. They use a mediator to facilitate the conversation, ensuring that both parties' interests are protected and that the agreement is a fair reflection of their shared goals. This proactive approach is the reason why second marriages in the 2020s are showing a higher rate of financial stability than those in the 1990s. The final element of our masterclass is the shift in social perception. During the economic boom of the 90s, divorce was often seen as a failure of character. In 2026, a mediated divorce is increasingly seen as a sign of high emotional intelligence and financial savvy. It is a strategic pivot. The individuals who lead the most successful companies in the US are the same ones who use mediation to handle their personal transitions. They understand that in a complex, globalized, and digital economy, the most valuable asset you have is your ability to negotiate a peaceful resolution. As we conclude this retrospective look at divorce mediation, we have traveled from the high-flying days of the 90s tech boom, through the wreckage of the 2008 crash, into the volatility of the crypto era, and finally into the holistic behavioral-driven models of 2026. The journey has shown us that mediation is not just an alternative to court. It is the superior financial and emotional technology for the modern American. It is the only system that allows you to dismantle the past without destroying the future. The history of the US economy is a history of cycles. There will be more booms and there will inevitably be more busts. But for those who have mastered the art of mediation, the cycle doesn't have to be a threat. It is simply a variable to be managed. You now have the blueprints, the case studies, and the historical data to understand how the elite have protected their fortunes through the most turbulent times in our history. But there is one final question that remains. As the world moves toward an even more automated, AI-driven financial landscape, how will the very concept of a settlement change? We are already seeing the first whispers of a new kind of mediation, one that doesn't involve humans at all. In our next series, we are going to look at the rise of the algorithmic divorce. We will explore the world of AI mediators, automated asset tracing bots, and the future of the zero human intervention settlement. You will see how the lessons we've discussed today are being coded into the next generation of legal software, and why the human mediator might soon become the most expensive luxury in the world. The future is coming faster than anyone predicted, and the way we settle our lives is about to change once again.